Welcome to Steno Compendium. Get ready for the dictation.
5 seconds. The moot issue that has stemmed in this appeal by grant of special leave is whether an order of dismissal of the counterclaim being barred by principles of Order 2, Rule 2 of the Code of Civil Procedure can be set aside in exercise of revisional jurisdiction under Section 115 of the CPC or in exercise of power of superintendence under Article 227 of the Constitution of India, or is it required to be assailed by preferring an appeal? The factual score need not be exposited in detail. Suffice it to state that one Fulan Rani, wife of Om Prakash, and another instituted civil suit number 107B of 2003 seeking a declaration that they are the owners in possession of the land measuring 1/9 share in the suit land, and further praying for permanent injunction against the defendants. After issue of notice, the defendants entered contest and the defendant numbers 12 to 14 filed a counterclaim putting forth that they had the right, title and interest as the original owner Jethram had executed a will dated 18/5/1995 in their favor. After the counterclaim was filed, defendant numbers 1 and 2 filed an application for dismissal of the counterclaim on the foundation that the same did not merit consideration as it was barred by Order 2, Rule 2 of CPC. It was set forth in the application that a suit for declaration was earlier filed by the present appellants along with others against the defendants, and a decree was passed in favor on 21/9/2002, whereby it was held that the present appellants and some of the respondents were entitled to one-fourth share each. The judgment and decree passed in the said suit was assailed in appeal, and the appellate court modified the judgment and decree wide judgment dated 15 to 2003, holding that each one of them was entitled to 1/9 share, and the said modification was done on the ground that the property was ancestral in nature and the sisters had their shares. After disposal of the appeal, one of the sisters filed a declaratory suit to the effect that she is the owner in possession of land in respect of 1/9 share in the suit land, and in the said suit a counterclaim was filed by defendant numbers 2 to 14 stating that they had become owners in possession of the said property on the basis of a properly registered will dated 18/5/1995 executed by Jethram. In the application, it was set forth that the counterclaim had been filed in collision with the plaintiff, as the plea of claiming any status under the will dated 18/5/1995 was never raised in the earlier suit. It was urged that the plea having not been raised in the earlier suit, it could not have been raised by way of a counterclaim in the second suit, being barred by the principles of Order 2, Rule 2 of CPC. The learned trial judge adverted to the less in the first suit the factum of not raising the plea with regard to will in the earlier suit, and came to hold that the counterclaim could not be advanced solely on the ground that the existence of the will had come to the knowledge of the defendants only in the year 2003. Being of this view, the learned trial judge allowed the application filed by the defendant numbers 1 and 2 and resultantly dismissed the counterclaim filed by the defendant numbers 12 to 14 wide order dated 13/10/2010.